You have 20 minutes. Of course, you're not required to use all 20 minutes.
Thank you, Your Honor, and good afternoon, Your Honors. May it please the court, Vinnie Luzzi on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal time. I will be arguing for 9 minutes, and amicus will be taking the rest of the allotted time. Now,
Okay, have you know that y'all are responsible for keeping that? I will try to remind you, but I take no responsibility whatsoever.
thank you, Your Honor. Yes, Mr. Taylor reminded me of that this afternoon. Now, we're here today on a significant issue that raises public policy concerns for first responders who suffer from heart arrhythmias pursuant to Section 112.18. Now, as we know, Section 112.18 creates a rebuttable presumption for occupational disease, firefighters, and first responders who suffer from heart disease or hypertension. In order to satisfy the presumption, the first responder must meet the 4 elements of the criteria. Well, in this case, the parties agreed before the JCC that the appellant met 3 out of 4 of the elements. He was a firefighter who successfully passed a pre-employment physical upon entry into service that failed to reveal evidence of heart disease, and that on the date of the accident, he was disabled as a result of his AFib condition. So the issue before the JCC was whether the AFib condition, a heart arrhythmia, was considered a protected condition of heart disease under the statute. Now, this issue only arose following the decision in North Collier Fire Control and Rescue District versus Harlem. Prior to the Harlem decision, there was no question that a heart arrhythmia was considered heart disease. However, the JCC here relied on that Harlem decision and found that the appellant's AFib was not considered heart disease because it was not a disease affecting or weakening the heart muscle through a degradation of the vessels or valves. Now, our position today is that that Harlem case is limited. It's limited to its specific facts and the condition involved in Harlem, and that it was an error by the JCC to rely on the Harlem decision when interpreting the term heart disease as it applies to the appellant's AFib condition.
So my understanding of Harlem is we basically said that the aorta was not the heart.
Correct, Your Honor.
Okay.
Yes. And Judge Tannenbaum, I know you wrote the order to Harlem, so I hope we can have a good discussion on what this means. However, I actually agree with Harlem. I would agree that a thoracic aortic aneurysm that did not involve valvular surgery would not be considered heart disease. And I think that was the distinction, and I believe that was the extent of Harlem. You know, Harlem, again, dealt with the aortic aneurysm. Harlem was presented with conflicting IME testimony before the JCC. Claimant's IME said, yes, that aortic aneurysm is heart disease. Carrier's IME said, no, it's not heart disease. And so the JCC in Harlem looked at our other aortic aneurysm case, which was the City of Venice v. Van Dyke, and held, yes, it is heart disease based on this decision. However, as this court noted in Harlem, they reversed that decision based on the difference between having the valvular surgery versus not having the valvular surgery with the aortic aneurysm. And the point being is that that is the holding of Harlem. Harlem held that a thoracic aortic aneurysm without valvular surgery is not a protected condition under 112.18. And I believe that is the extent of Harlem.
But why? What is the analysis that supports that holding?
And I certainly will get into that, Your Honor. The
Well,
Harlem
that's
court,
part of the holding itself, right? So, yes, if you could answer that.
correct. So the Harlem court went into 14 or 15 different uses of the term heart disease. They looked at various literature, various legal reviews, primarily from the 1950s and 60s, to get to their holding that the aortic aneurysm without valvular surgery was not heart disease.
And you understand why it was the 50s and 60s.
Absolutely, Your Honor. That was the enactment of the statute in 1965. Now, I would pose that the aortic aneurysm does not fit in any of the 14 uses of the term heart disease in Harlem. However, AFib would fit in 9 of them. And so I believe that the Harlem court was specifically looking at the condition of the aortic aneurysm to determine whether or not that condition constitutes heart disease. And I will note, and I'm sure that Your Honors have read in the briefs, the IMEs here unanimously agree AFib is heart disease. They agree that AFib was considered heart disease in the 1950s and 60s. They agree that AFib is a disease of the heart muscle itself. We're not dealing with the structure of the heart. We are dealing with the heart itself. And when somebody is in AFib,
Yet ironically, in Van Dyke, it was the structures of the heart that was pivotal for that decision. And what are the structures of the heart here that would be, that are involved with AFib?
correct, Your Honor, and I would say that we're not dealing with structures of the heart.
Right, so it wouldn't have fitted under even the definition or the discussion of Van Dyke, which then we distinguished in Harlem, and now you're trying to limit Harlem and say, even though AFib wouldn't have fallen under Van Dyke, which we narrowed, it would fall under Harlem, which was narrowing Van Dyke. So explain, so now you want to expand it beyond what Van Dyke said, it's more than just structures of the heart. It has to do with the heart in some way.
Well, no, Your Honor, I think Van Dyke listed the Dorland's Medical Dictionary, right? Any organic,
Yes.
functional, or mechanical condition of the heart or its structures that causes trouble. And Van Dyke said, okay, well, we're talking about the structure of the heart, the aortic aneurysm fits into that definition, boom, we have heart disease. Harlem said, no, look at these visual interpretations that Van Dyke relied on, and this is why it's so wrong. The aorta is the largest artery in the body. It goes from your chest to your stomach. So as the Harlem court noted, arguably if you have an aortic aneurysm in your stomach, is that heart disease? No, and I would completely agree with that. The difference here is we're talking about atrial fibrillation, which this court has recognized in the past, and I've noted that in the Marks and the Carney decisions, where both doctors agree this is unequivocally heart disease. It is in the atrium of the heart, which is a chamber inside the heart muscle. It causes a decreased function of the heart. It leads to heart failure. And if untreated, it can actually damage the heart muscle and the heart valves. And so my point being today is that Van Dyke and Harlem would really have no applicability when you're looking at an AFib case. What is heart disease as it stands right now is a question for the doctors. And
Why? They're not lawyers, and we're talking about a statutory term. So, and you saw that even in Harlem, you had, and we just talked about in the last OA, you can find apparently a medical professional to say something on either side in a lot of these cases. And that's what you had in Harlem. You had one doctor saying it is heart disease, and another doctor saying if you ever went to medical school, you would know the aorta is not part of the heart, so what are you talking about? So now you're arguing we should have doctors tell us what is and is not heart disease without any understanding what the statute says.
well, Your Honor, I would say, and I know this was kind of hinted and discussed in Harlem some, but what is heart disease? The doctor, based on their experience, what medical definition, what they would use, would look at the term and say yes or no based on their knowledge. If Harlem tells us we're looking at heart disease from 1965, so if we have to ask the doctor, hey, does AFib fit within the medical definition of heart disease from 1965? If they say yes, then I think that goes to their opinion.
Sure, except that that's not what we really said in Harlem. I mean, in Harlem, the point was, well, if you ask the average person in the 1950s and 60s, say even a legislator, what is heart disease? Most people are going to say it's, the thing that results in a heart attack, the usual, clogged arteries, that kind of thing.
Correct, and I would agree with you, and I would also add that if you ask somebody in the 1950s and 60s, is AFib or heart arrhythmias considered heart disease, you would get a yes. And I think this also goes to kind of a bigger picture here with what was the Harlem court doing? And I actually believe that, Your Honor, when you were discussing the thoracic aortic aneurysm, you were limiting that analysis to the aortic aneurysm. You were seeking to exclude a condition not properly designated as heart disease based on the conflicting medical testimony. And you made it a point to note that the employer's main contention in Harlem was that under the circumstances of this case, where it did not involve a valvular surgery, it was not heart disease. And the court noted, we agree, and we vacate the order. Then, after the analysis, after the discussion of the 14 different terms of the use of heart disease, the final paragraph, coming back to this case, we apply the term heart disease as basically the type of disease affecting and weakening the heart muscle through a degradation of the vessels or valves. The court didn't say, under 112.18 going forward, heart disease is defined as a disease affecting or weakening the heart muscle, etc. The court made it a very clear kind of difference, or so to say, that to this case, to these facts, this is how we're applying the term heart disease.
What you're saying is, we didn't really have an occasion to address AFib. It would have been irrelevant, so why discuss it in the context of talking about structures of the heart and that kind of more physical processes?
And certainly it would have been irrelevant to discuss AFib at that time, but the point is JCCs now, they have taken the Harlem analysis of heart disease and how you got that the answer to a thoracic aortic aneurysm was not heart disease, and applied it to every form of heart disease out there. And if you look at Harlem, and I'm monitoring my time, I'm running out here. If you look at Harlem, only 2 forms of heart disease would apply post-Harlem: clogged arteries and valvular issues. That's not the purpose of 112.18. There's so many other forms of heart disease that the doctors here addressed, and they stated there are more forms of heart disease. But I will reserve the remaining part of my time and let amicus make their argument. Thank you, Your Honor.
Good afternoon, Your Honors. My name is Nathan Cook. I'm here today representing the Florida Department of Financial Services. May it please the court. The department's goal in this matter is different than the appellant's. Our goal is to ensure that the Florida workers' compensation system operates accurately, consistently, and effectively. However, this court's decision in Harlem threw chaos into that system by establishing an under-inclusive and ambiguous definition as the term is used in the Heart and Lung Statute, section 112.1.
So I just heard your co-counsel say that Harlem was correctly decided. Do you disagree?
No, Your Honor. The department does not contest the decision of Harlem. We just contest a particular analysis of Harlem as to what heart disease is. We believe it's under-inclusive.
So your argument is that the JCCs are interpreting Harlem wrong?
Yes, Your Honor, that is
Okay.
correct.
Go ahead, Judge.
Yeah, because I thought your co-counsel was just distinguishing Harlem and pointing out that Harlem was addressing a particular problem and wasn't addressing this other,
Yes, to clarify,
these
Your
other
Honor.
aspects.
Yes, sir. I would say that the way it is read literally, it seems to be under-inclusive, and the JCCs are interpreting as under-inclusive.
With respect to AFib and the purpose, and that's where your co-counsel left off, the purpose of the presumption statute, and you heard it in the last OA, it's to skip past, so there are these conditions, you saw in the 1950s and 60s, there are these conditions that police officers or firefighters and then police officers were suffering from. Typically, it was interfering with their ability to get their pension because they would go out on disability early, and so this was, so just created a presumption statute as a benefit to the firefighters and police officers. But presumably, on the backside of that, the idea is that there are these conditions in work that can trigger a disablement through heart disease, tuberculosis, or hypertension. And we're going to save the police officers and the firefighters, other first responders, from the burden of proving occupational disease in the first place, and create a presumption instead, and then push it on to the employer to prove otherwise. With respect to AFib, is your position that there are circumstances where there actually are environmental work environment conditions that can trigger AFib, such that this statute, the policy of this statute, would be accomplished by reading AFib into heart disease?
Yes, Your Honor. The amicus brief cites the 5 medical publications that clearly established at the time of the passage of the Heart and Lung Statute that AFib was considered heart disease. Heart disease is not 3 conditions. It is an umbrella term today as well as it was back then at the time of the heart and lung. And AFib and arrhythmias, things that may be interpreted as excluded under the Harlem definition would be included under the understanding of a skilled person using the word heart disease at that time. For the last 2 years post-Harlem, and that's, the appellee argues that we're bringing nothing new to the table, and I completely disagree with that. For the last 2 years, we've seen inconsistent JCC rulings as to whether AFib is heart disease. We believe the department suggests that the primary reasons for those inconsistencies are three things. One, it's inconsistent with precedent of this court, which the appellee briefs primarily dedicates time to. So we will be breezing over that. The second is that we believe the Harlem definition is inconsistent with the plain language of the statute. And lastly, we believe that the definition is inconsistent with medical science. Specifically as to this court's precedent, and again, just gonna briefly notice this, Harlem did not distinguish, did not overrule, and did not mention any of this court's prior precedent in its opinion. Therefore, the JCCs, as well as the department, is struggling in understanding which precedent applies when we're looking at an AFib heart disease compensation case. So, as we've seen in Hart, as well as Toomey.
Why couldn't they follow the last decision of this court on an involving AFib?
Well, that's been some of the JCCs, but these other precedents from this court are specifically speaking to AFib. So it seems to be more on point than Harlem would be. Two cases that I would like to mention. The analysis of the JCC seems to a shotgun approach in doing its analysis, and I'll explain that. Those two cases are Hart v. Lake County Sheriff's Office, as well as City of Delray Beach versus Tomei. In those final compensation orders, the JCCs do a shotgun approach, like I was saying. They find that AFib meets Harlem, they distinguish it from Harlem, they find it meets Van Dyke, and they find that it meets the precedent from other precedent of this court. So you can see the confusion or the misunderstanding of what Harlem does to AFib in that context. Moving on to the plain language of the statute reason as to why Harlem is inconsistent. The term heart disease, while medically complex, is not ambiguous. It doesn't have two meanings. The term heart disease was established and developed by the medical community and has been followed, that the community that uses the term has followed the medical community into the future and their advancements.
If that were true, then how is it that in Harlem you had two doctors on either side, on opposite sides, saying that something was heart disease and something wasn't heart disease? And all purporting to follow the same medical science.
Your Honor, it is a medical complex question. I would say that opinions do differ reasonably, and there may be differences on that. However, the overall scientific community has a general understanding of what heart disease is, and it was clear back at that time in the 1960s as well.
Counsel, so AFib can, in theory, produce damage to the heart. Is there any evidence in the record here that it did damage the claimant's heart?
Not past tense, that it may cause damage in the future, and that's a distinguishing decision between different JCC outcomes. For example, in the Hart case that I mentioned, the JCC analyzed that it may cause, therefore it meets the definition of Harlem, whereas in Durden, the opposite approach, where it has not yet caused the damage, therefore it is not compensable.
Right, but the latter, right, is that, do you agree is consistent with the way Harlem has framed, whether you like it or not, is that consistent with the way Harlem has framed heart disease?
I would say yes, although I would say Harlem is ambiguous, so you could read it in multiple directions. I did want to point out that Harlem is also...
You're well into your rebuttal time that you were saving for co-counsel.
Oh, I'm sorry, let me end there, Your Honors.
Okay.
Any other questions? Thank you.
I will add an additional minute because we asked some questions there at the end. Of course, the other side, that gives you 21 minutes if you choose to use 21 minutes.
Hopefully I will not use all 21 minutes. Good afternoon. My name is George Helm, and may it please the court, I represent the appellees, the St. Lucie County Board of County Commissioners and PGCS Claim Services. We respectfully request the JCC's order be affirmed because there is competent evidence supporting the JCC's finding of no condition or impairment of health. So the heart disease definition doesn't matter, and Harlem does not need to be readdressed for the court to decide this case.
So
Even if-
AFib is not impairment of health?
Not one incident of AFib on vacation that clears up after a dose of cardizem and it doesn't reoccur. It's undisputed in this case that there's no heart damage at all.
Okay.
Now, there's a risk of heart damage, but as I heard in the last oral argument, risk does not produce injury. And to have impairment, you have to have, in my opinion, you have to have injury, based on plain reading of the definition. Now, I think even if
Having to go to the hospital during vacation is not an impairment?
no, not under not if there's not heart damage, because I think the focus is on the heart in these cases.
Well, if there were hypertension, then there wouldn't be heart damage necessarily, but there still might be impairment. If there's tuberculosis, obviously there's not gonna be heart
If-
damage, but it's still possibly impairment.
Yes, if the court were to conclude that the risk of injury is enough for there to be impairment, I think that analysis.
No,
would
I'm
be-
asking about, like, you're on vacation, you hope to actually just go to the beach and hang out and relax, and suddenly you find yourself going to the hospital. That seems like an impairment on your plan for the day. It certainly puts a damper on it.
Yes, and if you were to look at it that way, I can see the point, but the impairment by definition is to injure or to cause harm to something. And here, if the focus is on the heart, that one incident of atrial fibrillation had no effect on the heart. No effect on his heart. Now, did it create a risk that he might have some effect down the road? Yes, I suppose it did.
I mean, but
did
it sounds like you're looking at the wrong end of the statute, because there's two participles.
Yes.
There's one at the beginning and one at the end, so an impairment caused by, and then also, did it cause disablement or death, which sounds like more like what you're talking about.
No, I think that disability.
Which would be, you'd actually have to have some sort of injury that pulls you out of work in some way.
I would respectfully assert it's the opposite, that the time off from the hospital could potentially be disabling because it would affect his capacity to earn, but would not necessarily impair him. Okay, especially since he recovered without any heart damage. Now, I would also assert that even if Van Dyke applied to this case, it wouldn't be compensable because there's no condition or impairment of health caused by the atrial fibrillation. This AFib incident had no effect on Mr. Durden's heart. Remember, the focus in
But
all
just to
of
be
this-
clear, but just to be clear, are you saying that it wasn't an impairment in health, or it wasn't an impairment in health causing a disability?
It wasn't an impairment in health because it did not cause any heart damage. Now, it did result in a brief period of incapacity, but incapacity or disability is also different than impairment. Firefighter Durden suffered an episode of atrial fibrillation while on vacation on August 24th, 2023. He sought compensability of his atrial fibrillation condition solely on the basis of section 112.18. For application of 112.18, he has to prove he suffered a protected condition. A protected condition is any condition or impairment of health caused by tuberculosis, heart disease, or hypertension. Judge Stanton's order denied compensability because Mr. Durden did not meet this burden of proof. There are essentially two parts to this statutory language. A condition or impairment of health caused by tuberculosis, heart disease, or hypertension. Now, I think the standard of review is mixed if we get into a Harlem analysis, whether that definition was correctly applied. I think it's a de novo review. But whether the said disease here resulted in a condition or impairment of health is a factual matter subject to competent substantial evidence review. And in this case, the judge clearly found there was no heart damage. There is no statutory definition of a condition or impairment of health. So we look to the plain meaning of the words. Impair, now I could only go back to 1968, finding definitions, I couldn't find anything earlier. But impair in the Black's Law Dictionary in the 1968 fourth edition was to weaken, make worse, lessen, empower, diminish, or relax, or otherwise affect in an injurious manner. I also looked at the 9th edition, because I happen to have that one handy at my desk, and impair is no longer in there. Now impairment is defined as the fact or state of being damaged, weakened, or diminished. Now we know from the Caldwell case, Caldwell versus Division of Retirement, which we use as guidance, that the heart attack Mr. Caldwell suffered was a condition or impairment of health caused by coronary artery disease. In Caldwell, the focus was on the effect on the heart. We know from the Van Dyke case that they relied on any debilitating effect the aneurysm had on the heart rather than the location of the aneurysm. And we assert that a condition or impairment of health in the context of heart disease is the debilitating effect on the heart. Applying the same analysis to Durton, the judge looked to whether there was any debilitating effect on the heart caused by the atrial fibrillation, and there was none. He found there was no damaging or weakening of the heart muscle, and that finding is supported by competent substantial evidence and should be affirmed. The heart disease definition doesn't matter because there is no condition or impairment of health in this case. There is no actual heart damage. There's zero evidence that the single episode of atrial fibrillation while on vacation, after, I might point out also, he apparently had a few cocktails that day, had any impairment or adverse effect on the heart muscle. So his condition doesn't require any ongoing medications. So even under the Van Dyke definition, I don't think this would be compensable.
Well, what about, and I'll come back to how you would reconcile your definition of impairment with hypertension, if that were at issue. But are you saying he didn't suffer disablement? I mean, assume they're correct in everything. Assume that, AFib is heart disease, and it caused some sort of impairment because he, had to go to the hospital for something or other. Was there a disability?
In this case, we stipulated to disability. Trial counsel did. We went through the analysis. It was a close call, but he did suffer. And some of the, like the Sadaka case, that was also my case too. And believe it or not, Van Dyke was my case, and so was Harlan my case at trial. So I have a little understanding of this area. Essentially, disability is the incapacity to earn because of the injury. And
So you have, and your client stipulated to the
They
disability
stipulate-
part.
yes.
What caused the disability? What were they stipulating to?
They
as to what
stipulated to the
caused
disability because he was in the hospital because he had AFib. So they were basically checking him out. Now disability also requires you be incapacitated for treatment. But there can be a confusion or a gray line between treatment and actual analysis or diagnostic studies, et cetera. And I acknowledge in this case, if we looked in hindsight, say maybe we shouldn't have stipulated to disability because it was a close call. But we did, and there are a lot of reasons why. Mainly because our own IMEs have testified he was disabled, and so did the claimant. So it was sort of undisputed that he wouldn't have been unable to work during that period of time just because he had AFib. So just like sometimes if your blood pressure is a certain level, they're going to say you shouldn't work, period, just because you have hypertension, not because you're actually physically suffered some type of damage from it.
But if you stipulate to the disability, aren't you buying the sort of chain of causation that came before it? I mean, we can still discuss whether heart disease is broad enough to trigger the presumption, but if you're going to stipulate to certain aspects of the presumption, say yes, at least under, and it's not so much even under 112.18 as much as it's 440.151, where you're going to stipulate to disability or disablement, you're saying that if there is an occupational disease, it did cause disablement.
Yes.
But
That's because
but you're-
disability
but
and
you're-
impairment.
it seems like you're assuming then that there was something that happened, there was some health process, some physiological process with the employee that led to the disablement, and aren't you buying that as well?
There
when you
was a
stipulate?
diagnosis of atrial fibrillation that led them to say, and until your rate turns back to normal, you should not work, basically.
Sure.
Now, that wasn't assigned at the hospital. That was assigned actually after the fact when he returned. He saw a physician on behalf of the employer, and they restricted him until they could figure out exactly what was going on. But disability is not the same thing as impairment. Impairment requires actual damage if you look at the plain meaning of the word. And there's no actual heart damage here.
So then to come all the way back around, so if this were a hypertension case, how do you measure impairment?
Same way.
I mean, so,
Is there any-
and my question, so same circumstances, he's, on vacation, and suddenly he feels, I don't know, lightheaded or whatever, you get, a spike in your blood pressure, and you have to go to the hospital, and they figure out, oh my God, you got high blood pressure, and then they diagnose him with hypertension. They say you should be out of work for a week. but there's no damage to the heart. How do you measure the impairment aspect under
Well,
your definition?
I'm gonna get to that now. You know, I've been handling these cases at the trial level for a pretty long time. If I had an inch in height for every time I was told I was being too technical by a judge, I would be playing center for the LA Lakers, okay? It's, and we made those arguments early on, and we did not prevail in many of the cases. And that is, there actually has to be a condition or impairment of health caused by the hypertension. But in reading recent court opinions, the court has entertained the idea of actually looking at the actual language. And the language requires a condition or impairment of health caused by the hypertension and caused by the heart disease. So I would argue that you have an argument in a hypertension case now that if there's not an actual condition or impairment of health caused by it, like left ventricular hypertrophy or you know, some type of disease with the eyes and other things that hypertension can cause, then you don't have an impairment. Now, but if the court were to find that risk of those things alone is enough to be an impairment, then maybe there is an impairment just the fact of having hypertension. But in this case right here, my position is none of this matters. There's no heart damage. He does not have a condition or impairment of health. He had one episode of atrial fibrillation. If he has another episode down the road and he's working as a law enforcement officer and it does lead to heart damage, he can have another claim. And it might be compensable.
So his AFib is not a condition, or the manifestation of AFib is not a condition?
If he has an actual manifestation caused by the AFib, looking at the plain reading of the statute, then I would argue that he might have a condition or impairment of health. But he has nothing that the atrial fibrillation caused here.
Why did he go to the hospital?
He went to the hospital because he had AFib and he has risk. Okay,
But
just
how
like-
did he know he had AFib?
I think
Did his
felt the
Fitbit tell him,
well,
or did he?
he's probably, now I don't know the exact facts of his training, but I'm assuming he's a firefighter, which means he's an EMT or a paramedic. And I would guess that he understands the different rhythms, and he actually said, I felt like I had something abnormal rhythm going on, and went and got tested.
But you don't consider that to be a condition? Even though he felt it, he experienced it, something's off, that's not a condition of health?
Not if it does not result in an actual impairment or something, some type of damage to the heart.
But it says condition or impairment of health.
Yeah, there's no evidence of there being a condition. No one testified he had a condition of health at all.
Except his own experience that he
Yeah, that he had
felt something irregular.
Yeah, now if the court were to find that's
That he
enough.
was right about, as it turns out.
Yes, if the court were to find that that's enough, then I don't have an argument. If you're
On
finding out there
condition
doesn't have to
part.
be some type of damage to the heart, then I don't have an argument.
On the question of
On that
condition,
issue,
yeah.
condition or impairment of health. Now, I do think that Harlem is precedent. It's precedent because the court endeavored to define heart disease. They did it as part of the holding, and it's precedent. I think that now, did Harlem ignore prior precedent? It explained and distinguished Van Dyke, but all of the other cases that are allegedly prior precedent, the definition of heart disease was not an issue. No one fought it. Things were accepted as heart disease. Atrial fibrillation was accepted as heart disease because no one fought it. They just accepted it because the doctors told us it was heart disease.
So would you consider there be no prior holdings of this court on the subject of AFib being heart disease?
Not where it was an actual issue as part of the hold necessary to the court's holding. Okay, there's plenty of opinions where atrial fibrillation was accepted as a condition under 112.18, but nowhere where it was discussed and fought about.
Is it possible that Harlem could be read to not be exclusive, but an exclusive definition of heart disease, but addressing the circumstances in front of the
You
court
mean
at that
just
time?
like exclusive to like atrial?
Well, I mean, let's say, your opponent said, well, Harlem could be read, so if you're looking at aortic aneurysms and whether, distinguishing that, and, a physical aspect of the heart, and we were discussing in that context, and it didn't even come up as to there could be other non-physical processes or whatever, and
I think if the opinion was written differently, it could be. Like if the opinion was written that, and the court just concluded that the aorta, thoracic aorta, is not a structure of the heart, and didn't get into redefining heart disease, then there would be a much stronger argument that Harlem was limited to things like the thoracic aortic aneurysm. But I think the court specifically said in Harlem they were going to they endeavored to redefine heart disease, and they did. And we look
Not
at that.
redefine it, capture what the original meaning of
Capture what the
heart
original
disease
meaning was.
is.
And I agree with, when this statute was created in 1965, that's probably what people were thinking about. I'm not saying that atrial fibrillation wasn't heart disease as defined by physicians back then, because I'm certain it was. But when people thought about firefighters, because firefighters were the only ones covered by the law then, they probably thought about firefighters having heart attacks after fighting fires.
Well, so, on this topic, I don't know to get too theoretical, but on the, when we endeavor to do original meaning analysis of a statute, we do our best to, find, go back to the 1950s. If we wanted to find out what it meant in 1880, I assure you it would have been a lot harder than even 1950 or 60. So, we do our best to figure out what the original meaning was, and is it not acceptable, if not incumbent, on a party that says, hey, actually, we did more research, we did better than you did, court. We found all this other evidence of what the original meaning could have, and it's actually broader than what you said. Is
Yeah.
that,
No, I think that's
what's your
our
response
response.
to their position that actually, if you go back and look at some of the other literature,
Yeah,
it's actually broader and includes
Yeah.
AFib?
I have not researched this, but I would accept the conclusion that the definition of heart disease by physicians in 1965 included atrial fibrillation. But I also accept the conclusion that when the legislature was passing this law in 1965, they weren't thinking about atrial fibrillation. Probably, and I haven't researched this, but probably because it wasn't as understood back then as it is now. It is prevalent. I can tell you that from a practitioner standpoint, I see as many AFib cases as I do CAD cases, a lot of them. And that may be due to various factors, but the reality is back in 1965, I'm not sure it was understood well, but it did exist, and it was heart disease.
And then one of the flaws in the original meaning sort of theory or approach is there's no way to know actually not that you can even assess what, or even whether it matters what an individual legislator understood at the time. We're supposed to look at, because generally speaking, what was understood, and I don't know, does it matter that the medical community understood it? Because you don't know if the legislators talked to the medical community when they're drafting the statute. And so now we know, how do you make that kind of call?
Unless you have a time machine, there's no way to do it with certainty. But I think it's logical to assume that atrial fibrillation was heart disease in 1965, but it probably was not as prevalent and as understood. And it probably was not what the legislature was thinking about when they passed the law, because they were dealing with heart attacks.
Unless it was possible legislature, and we've already described several times today alone as to what the purpose potentially was for the statute in the first place. And, if they knew about it, it's possible they weren't going to exclude one thing that firefighters and police officers were suffering from in favor of another.
Yeah, no, I would agree with that. And it's, I think the statute was a piece of public policy legislation to give a benefit to firefighters, because they basically probably saw firefighters having heart attacks after they were fighting fires.
Does that mean we should more broadly construe a statute like this with that understanding? Or is it a neutral, strictly construe? What do you think?
Oh, that's tough. I don't really think that's my call. It's above my pay grade. But my position here is that none of this stuff really matters in this case, and because there's no condition or impairment of health. If you're gonna focus on the strict statutory language, it's a condition or impairment of health caused by tuberculosis, heart disease, or hypertension. If there's no condition or impairment of health, then the presumption doesn't apply. It's that simple. So we request that the JCC's order be affirmed, because there's competent substantial evidence to support it. Thank you for your time.
Thank you.
Thank you, Your Honors. The first thing I'd like to address on the rebuttal is the impairment or the damage to the heart, which I think Judge Ray, you brought up. I'd first turn to the Harlem decision, and what I previously mentioned, where the Harlem court looked at the different uses of the term heart disease, about half of the 14, so about 7, they talk about the risk of developing heart failure, or the risk that it can lead to a heart attack. Not absolutes. You know, there's nothing in the statute that says heart disease has to involve structural damage. There's actually a whole another category of structural heart disease. And arguably, you know, hypertension, coronary artery disease, several forms of heart disease that we know and recognize as heart disease would not be considered structural heart disease. And so that's my first point on the impairment of health. My second point on the impairment is that both doctors actually testified that on the date of the accident, the appellant suffered an impairment of health due to his heart disease.
Well, that's a legal conclusion. That's, again, we're back to doctors interpreting statutes or applying statutes, right?
Arguably, at the same time, I think the doctor was also just acknowledging that, again, he was in the hospital, received medication for heart disease. And so from the medical perspective, I think he was saying he was impaired due to his heart disease.
I mean, wouldn't it have been enough for your client to testify, yeah, I felt something was wrong, and so I went to the hospital, and then they told me I should be out of work for a week because I have AFib.
Your Honor, I would like to agree with you and say that's sufficient, but I think as these heart bill cases have kind of progressed, I think we need the doctors to confirm that, to kind of confirm the disability element. But again, with the impairment issue, you know, again, both doctors testified that he did suffer the impairment of health due to heart disease. Both doctors also testified that Mr. Durden will require future medical care and future doctor's visits because of this AFib. So they are clearly recognizing that he has suffered some sort of condition that's going to require ongoing treatment. This wasn't a one and done thing. And lastly, if Mr. Helm will recognize that AFib was considered heart disease in 1965, I think a doctor would recognize that AFib was heart disease in 1965. Therefore, I think the legislature would have recognized AFib as heart disease in 1965. So, Your Honors, we implore you to reverse this decision, because I think it's clear based on both doctors' testimonies that Mr. Durden suffers from AFib, a heart condition, a heart disease, that impaired him from performing his duties on the date of the accident. Thank you.
Thank you. Thank you, all counsel, for your arguments today. Thanks to court administration, the sheriff's office, and Judge Davis for hosting us. We are adjourned.